At sea, when food is gone and no rescue is visible, what counts as necessity? The question sounds abstract until you place it inside a small open boat in the South Atlantic, 24 days from the nearest port, with 4 people and almost nothing left to drink. In the Mignonette's boat, the answer depended on a harsher question: who still counted as crew? 24 days after the yacht went down, one of them would be dead. Not by storm, not by thirst, but by a decision made inside the boat. The case that followed is usually taught as a landmark in criminal law, a conflict between individual survival and the rule against murder. That framing is accurate. It is also incomplete. The law court asked whether necessity could excuse a killing. The lifeboat had already asked something else. Which of the 4 people aboard was still a full member of the crew, and which had become something less? Mignonette was not sailing a grand expedition. She was a yacht being delivered from Southampton towards Sydney by 4 people, whose names would later be sorted into roles by the law. The vessel was a yawl-rigged sailing yacht, 52 feet in length, built for coastal waters and private ownership. The delivery passage to Australia required open ocean sailing well beyond what a yacht of her type was designed to handle routinely. Thomas Dudley was the captain, not a naval officer, not a man of independent wealth, but a working sailor paid for a job and accountable for a vessel that did not belong to him. Edwin Stephens sailed as mate. Richard Brooks was the seaman, and there was a 4th. Richard Parker, a young cabin boy from Southampton. He was the youngest aboard, the least experienced, the one whose role in the hierarchy of a working crew sat lowest. His name would become the 4th name in a legal record he did not live to read. The 4 of them departed mid-May 1884, bound south and then east, into water where help, if needed, would be slow in coming. The fatal assumption behind the voyage was not that the sea would be kind. Sailors of that period understood the South Atlantic. The assumption was more specific and more dangerous: that if the yacht failed, 4 people and almost no emergency stores could still remain a crew. Mignonette was not provisioned for an extended survival situation. The lifeboat was small. The crew numbered 4, and the balance between those 4 was unequal in ways that did not matter while the yacht was intact and became critical the moment she was gone. After Madeira, the voyage moved out of the geography of ports and into the arithmetic of distance. By early July, the nearest help was not a place, it was chance. The boat was approximately 1,600 miles from the Cape of Good Hope. The shipping lanes in that part of the South Atlantic were real but not dense. A vessel could pass within miles of a distressed boat and not see it. Before it was a legal case, it was 1,600 miles of open water. On the 1st of July, a sea struck Mignonette, and the yacht began to fill. The men got clear, but what reached the boat mattered as much as who reached it. The yacht went down quickly. No fresh water was secured. Almost no food came off the yacht. The stores in the lifeboat were minimal to begin with. A human body can survive weeks without food. It cannot survive much more than 3 days without water. Thirst in that situation does not produce calm deliberation. It produces deterioration, first in physical capability, then in mental clarity, and eventually in the capacity to make or understand decisions at all. Around day 4, the men caught a turtle. It gave them food and fluid, enough to slow the worst of the deterioration. Rain fell at intervals and was collected. These reprieves were real. They extended survival. They also prolonged the situation rather than resolving it. By day 12, the food was gone again. By day 19, Parker had begun drinking seawater. It is a reliable marker of desperation. Seawater accelerates dehydration, and anyone familiar with survival at sea understood what it meant. Parker was failing faster than the others. By day 20, the boat had become a courtroom without a judge. The record says that lots were discussed. That phrase carried a specific meaning in the maritime context of the 1880s. The custom of the sea included a procedure by which men in extreme survival situations could draw lots to determine who would be killed to feed the others. It was not a legal procedure. It was not sanctioned by English law, but it was understood as a tradition, a rough form of equal chance imposed on a situation that had no good outcomes. The record also says no equal procedure survived. The record does not tell us every word spoken in that boat, or what Parker said, or whether Parker, by then severely weakened, said anything at all. What the record tells us is that lots were proposed and that what happened instead was something different. Richard Parker was 17, or possibly between 17 and 18 in the legal record, with his home listed as Southampton. He was the least experienced person in the boat. He was the lowest in the crew order. And by the time the decision was made, he was physically incapacitated, incapable of resistance or comprehension in the period that matters. He was not a participant in whatever discussion took place. He was not someone who could have drawn a lot and accepted the outcome. The court would later ask whether necessity could excuse what happened. Before that question has any meaning, this one has to be answered. Who decided that Parker's life was the one the situation required? The boat had already sorted that. Parker was not the strongest. He was not the captain. He was the fourth name. Thomas Dudley and Edwin Stephens killed Richard Parker. The indictment charged both men with murder on the high seas on 25 July 1884. Everything before this explains the act. It does not excuse it. The circumstances were extreme. The act was real. Both of those things are true, and the law's problem was that they pointed in different directions. 5 days later, on the 29th day of the drift, the Montezuma appeared. She landed 3 survivors at Falmouth on 6 September 1884. The arrival ended the physical emergency. It began a different kind of crisis. Survival at sea had required one custom inside the boat. Now the survivors were back in a world governed by a different one, the law of England, which did not recognize what had been done as anything other than killing. At Falmouth, the men did not return as silent castaways. They gave the story to officials, and the harbor turned survival into evidence. Dudley, Stephens, and Brooks made statements. They did not conceal what had happened. There is no indication in the record that they believed they had committed a crime. The custom of the sea, as they understood it, had provided for exactly this kind of extreme situation. That understanding was about to be tested. The officials who received the statements were not operating under maritime custom. The harbor records show a rapid transition from arrival to legal process. What had been a survival account became, within days, a criminal matter. The first sorting happened on shore. Captain, mate, seaman, witness. The boat had sorted them one way. The court began sorting them another. Richard Brooks did not face the same charges as Dudley and Stephens. He became the witness for the prosecution, a role that placed him outside the legal jeopardy that fell on the other two. What had been a crew of 4, then 3 survivors, became 2 defendants and a witness. Brooks' position in the legal proceedings was different from his position in the boat, and that difference was determined by the law, not by anything that had happened at sea. The jury at Exeter on 6 November 1884 did not simply say guilty or not guilty. It returned a special verdict, a careful legal pause that admitted the facts were terrible and the rule uncertain. A special verdict allowed the jury to establish what had happened without determining the legal consequences. That question was referred upward to the Queen's Bench, to judges whose role was to determine whether those established facts constituted murder-in-law. The jury found the facts. The judges would find the law. The court's ruling on necessity went further than the specific facts required. It did not simply say that what Dudley and Stephens did was murder. It said that necessity as a general principle could not excuse murder, and it gave reasons. One of those reasons is the one that still matters most. The court observed that a necessity defense, if accepted, would allow the person who survived to be the judge of whose death was required. The beneficiary of the killing would determine its legality. The court found that arrangement intolerable. That concern was not abstract in 1884. It was a response to the specific facts before the court. A captain who decided that the cabin boy's life was the one the situation required, with the cabin boy unable to consent, resist, or participate in the decision. The court was afraid of more than one desperate killing. It was afraid of a rule that let the strongest survivor decide whose life had the least legal weight. The Queen's Bench found Dudley and Stephens guilty of murder. The sentence was death, mandatory under English law at the time. It survived because the court was forced to draw a line in a place where almost everyone could understand the temptation to cross it. The circumstances were as sympathetic as circumstances can be. The killing was still murder. Full sympathy, full condemnation. That combination is what made the case impossible to set aside. The legal principle extracted from R.V. Dudley and Stephens has since been cited in cases about resource allocation, medical ethics, and hypothetical conflicts between lives. In those contexts, the principle matters. But the maritime setting is not decoration. It is the reason the case happened at all. The custom of the sea, the duty of rescue, the crew hierarchy that sorted 4 people into captain, mate, seaman, and cabin boy. These were not background. They were the structure inside which one person's life was decided to be worth less than 3 others. In the Falmouth minutes, the entries moved through offices, warrants, summonses, and bail. The machinery of the law processes what the sea returned. Names become roles, roles become charges, charges become a case argued in front of judges whose job is to say what the law means. Then the name returns. The boy Richard Parker. 17 years old from Southampton, listed 4th in the crew. He does not appear in the legal proceedings as a defendant or a witness. He appears as the name the case is about, the person whose death the indictment was filed to address, the 4th member of a crew that the law, in its own way, was trying to account for. In the last record that matters, Richard Parker is not a legal problem. He is the 4th name in the crew.